Complaints about the Michigan child support system, the corrupt court system. So it's background on myself and what I'm here complaining about for the public, to the world, for them all to hear and understand that there's a serious problem within the court system that we need to fix somehow, some way, shape, or form. The fixing would start with judges deciding to be honest people with integrity, and lawyers deciding to stop being scumbags and be honest people with integrity, and cops to decide to start being honest people with integrity who go read the laws about the stuff they're told to go enforce before they go enforce it, so they know that they're not enforcing something that's not law, something fictitious that the court cooked up and put into an order. So I have prepared myself a motion to vacate child support order for lack of jurisdiction. And I'm pretty much just going to read this to you. The first 15 of 20 pages. If you want a copy of this, you could email me, which is my username narflux@protonmail.com. If you want a copy of any kind of legal document that I have, you could ask me if I have something of the subject, and if I have something relating to it, I'll send it to you. Okay, let us see how the share screen button works. Is there a share screen button? I don't know how the share screen button works. Well, I'll just read this to you. So, background regarding my case. In 2016, a child support order was filed against me, somehow, mysteriously, with no explanation. When I asked the court regarding it, there was no explanation. Oh, we don't know how we got it. We were told to prosecute you for support. In the Ontonagon County Court, a certain schemy man named Michael Finley, the county prosecutor, is the one who performed my prosecution. Did everything on behalf of the plaintiff, my time legal wife in the Philippines, who refused to come to America when her visa was approved back in 2013 after it took 2 years to get done. She claimed I had 2 kids, but the DNA tests that were done at some point later on, throughout the process, revealed that I only had 1 kid. I already had the knowledge that I only had 1 kid, but she never admitted it. And then when it came to going to court, she decided to lie about it, claiming she had 2 and not just 1. So in May of 2016, I went to court, which I should never have done. From what I've learned about, you just don't cooperate with these people when it comes to child support, because it's a private, arbitrary third party known as Michigan Child Support, which you can find on a website that lists private corporations. Name is not coming to me at the moment, but Mr. Rick, the paperwork guy, got a YouTube channel. He explains all this stuff, and he gives you paperwork if you give him a gift. I've attempted to use several of these things. I'm in the beginning process of it. I only started these shenanigans about a month and a half ago. So they're not shenanigans for me. The court's engaged in shenanigans, and I'm trying to write this stuff, and I'm trying to figure out if his paperwork even works. So far, the courts, the people I've talked to with the court claim, oh, I don't know what this is, your Google document. You got excuses to claim they don't know it and they don't want to read it or understand it. They probably don't, because they're a bunch of dumb people who think they're government employees working a government job when they're really federal contractors. They may be employed perhaps by a county, but in the capacity that they're operating, they're acting as contractors for the federal government, implementing a child support program, which I haven't wrapped my head around exactly how this even works, how the state and the feds and private corporations are somehow intermixed and intertwined in using county workers to do the groundwork, the legwork for them, to fill out the paperwork, to send you stuff, engaging in mail fraud by sending you threats. You're going to get arrested. We're going to take your driver's license. We're going to take your passport if you don't cooperate, which is a form of coercion, which I don't know of any other government agency out there that sends you threatening mail to get you to do something. Usually someone shows up at your door to say, hello, I'm from the IRS or whatever. They don't show up and say, we're going to take your passport. You could get arrested and we'll force you to work. Oh, essentially, they force you to work by threatening to arrest you if you don't work. So it's peonage. Peonage. They're forcing you to work. This video is all over the place. I'm no good at this stuff. So trying my best. I have filed, and I don't know if I can put all this in one motion or not, but I'm doing this. So I have a motion to vacate child support order for lack of jurisdiction. Motion to terminate child support order for lack of jurisdiction. Motion for court to exercise personal jurisdiction, which my ex-wife claimed to consent to during the initial hearing so that the court could even hear the case, with her never having been to the United States, living in a foreign country, not an American citizen. There's some fiction in law right there that they're pretending that works. So motion for court to exercise personal jurisdiction to order plaintiff to have a civil conversation to discuss financial support. I would think that'd be the first thing that a court would do instead of just going right to a collection service, third-party private collection service. They would tell you to have a conversation and maybe order you to seek counseling to discuss the financial well-being of your children, but they don't. Don't make a god darn bit of sense to me. It's certainly not common sense for them to go right to a collection service rather than say, hey, you should talk, and we're going to tell you to attend this meeting, just like they do with alcoholics in AA. And fourth part of this is demand for Title 4D Michigan Child Support Agency, quote, misdue to repay costs, administrative fees, and damages for all collections carried out under a void judgment for lack of subject matter jurisdiction. So I've got four things I'm asking the court here to do, and I don't know if I can really put it all in one document, but I'm going to try it. We're going to see what happens. So I'll begin to read this document. Whereas the court has never had jurisdiction in this case, as my son, Abel Reinfrost Campos Brook, Abel for brevity, was conceived and born within a lawful marriage between myself and his mother, Julie Campos Brook, Julie, or the mother for brevity, under Philippines law in the Republic of the Philippines, Philippines for brevity, and has lived his entire life to date in the Philippines, a non-signatory of the Hague Treaty that governs international child support and custody, and is a non-reciprocating country with respect to child custody and support agreements with the United States of America and the state of Michigan. The only valid and appropriate jurisdiction for this case to have been filed in and heard would have been at the appropriate court within the Republic of the Philippines, where the marriage contract was entered into. The child was conceived, born, and has resided since, as that is where the only evidence of jurisdiction is had. Its jurisdiction should require evidence. And that's why personal jurisdiction sounds like a form of legal fiction, because there's no evidence. And personal jurisdiction over someone who's not in the country, never been to the country, has no legal claim to be in the country, and the court with a non-reciprocating country, how could that court that supposedly has personal jurisdiction exercise any of that jurisdiction over the other person in a foreign country where there's no reciprocating process to do anything? Question mark? Philippines law regarding support is defined by Executive Order number 209, amended by number 227, the Family Code of the Philippines, Title 7, Support, and under Title 9, Parental Authority. In this brief, I've included copies of those sections in pages 16 to 20. So that's just specific to this document if you were to look at it. At no point have I ever received notice or any filings done through the appropriate court in the Philippines that would have jurisdiction to hear such a case. The court system in the state of Michigan, capital letters, state of Michigan, which is how they write it on all their documents because it's a corporation. It's not a sovereign government anymore since they incorporated and became a legal fiction, essentially. A artificial entity, not a sovereign government of the people, by the people, but an artificial corporation with a CEO and employees. That's how it would work. If they were to claim because you don't work for a company, they can't set any policies. Even if they try to set policies, you still got rights. But those policies do apply to their employees. So if a corporation claims to have the authority to tell you what to do, you would have to have been an employee for it. And if you ain't an employee for it, they don't have any authority to tell you what to do. So state of Michigan, the state for brevity, was an improper venue for the mother to seek any legal action of this nature, having not pursued action through the appropriate court in the Philippines, where the remedies under Philippine law have already been established. As a non-reciprocating country with regard to child support, the mother could claim to a Philippines court, I have not been supporting our son, and double dip, essentially. The proper jurisdiction and venue for support for our son Abel should his mother not be willing to come to an agreement on our own as reasonable adults, both concerned for the well-being of our son Abel, exists only within the Philippines. Because the kid's in the Philippines, and the mother's in the Philippines, and the marriage was in the Philippines. My son may have a report of birth abroad, but he doesn't have a residence in the United States to be under a court that would have jurisdiction because she never let him come here. He's never physically set foot in our country, sadly. Against my will, I'd rather have 50-50 custody with the lady, as any reasonable human being would if you don't want to have your family fixed, as she don't want. But she don't want. So, as a non-reciprocating country with regard to child support, the mother could claim to the Philippine courts, I have not been supporting our son, and double dip, essentially. The proper jurisdiction and venue for support for our son Abel, should his mother not be willing to come to an agreement on our own as reasonable adults, both concerned for the well-being of our son Abel, exists only within the Philippines, and therefore can only be heard in the appropriate Philippines court having jurisdiction. To ensure no double dipping or abuse of due process can occur to the non-reciprocating status under the Hague Treaty of the Philippines, due to the non-reciprocating status under the Hague Treaty of the Philippines. I may need to change some grammar right there. Yeah, of the Hague Treaty. I'll just add a comma right there. Non-reciprocating status under the Hague Treaty of the Philippines. Or better, I highlight that. Due to the non-reciprocating status of the Philippines under the Hague Treaty. Yes, better verbiage right there. Then I include a link. So for reference purposes, a complete copy of Philippine Family, or the Family Code of the Philippines, can be found at the web address below. Excerpts from Family Code are at the end of the document. So I have a link there, hyperlink, if they have the digital copy, or they would have to type it all the way out and they could find a copy of it. Read it in its entirety. So any kind of law, you should be reading in its entirety. You take one section out of it, you're probably going to miss the general context of the law. And with regard to law and interpreting law, which is this dirty argument these cops and judges and lawyers all come up with, which is just as crooked as it gets and absolutely false. They're not allowed to find an interpretation that fits what they want in a law or in words. The intent of the people who wrote the law and passed the law is how the law is to be interpreted. Because if there wasn't an intent behind the law wouldn't have been made. So if you're trying to understand a law or a document like the Constitution, you should go read the opinions of the people who wrote it, who passed it, which is what the Federalist Papers are for. Those are the opinions of the people who wrote the document. That's what you should be interpreting it by. Not looking for new meanings from new words or changes in definitions of words 200 years later, and then applying those modern definitions to a document that was written all that time ago, which had very different meaning when it was wrote and turned into a law. So I continue. So section 2 of this. Whereas, according to my son Abel and his brother, and the brother of Julie, Marvin S. Campos Marvin for brevity, in the late March 2022, his mother had left home to go to work abroad in Germany and claimed would not be back for 1 to 2 years. And during my time visiting and taking care of my son Abel for the month of April 2022, Julie was nowhere to be found and was confirmed to not be present in the country by her mother, Margarita S. Campos, and her brother Marvin. In late April of 2022, I had called the Keweenaw County Friend of the Court, which was the friend of the court with the controlling order at the time, or enforcing the controlling order, which was had at Keweenaw County Court. Circuit Court is the one that dealt with it. To bring this matter to their attention, I was told it was not their responsibility to know if Julie was there taking care of my son Abel, and that there was no system of accountability or process the Keweenaw County Friend of the Court has to follow should an event occur and be reported to them. Wherefore, that Julie is no longer present in the household where Abel is currently residing against my will, which in accordance with Philippine Family Code, or Family Code of the Philippines, that does matter. Father's opinion matters, according to Philippine Family Code, which I will go down and read this because this is a very important thing to read. I didn't write Philippine Family Code. I'm just a father and was a husband in the Philippines. I technically still legally am, because divorce is illegal even if I got a divorce in my country. Where are we? Which page are we at? Parental authority. That part. So Philippine Family Code Order, Executive Order number 209, the Family Code of the Philippines, Title 8 deals with support. Title 9 deals with parental authority. So, Family Code of the Philippines, Title 9, Parental Authority, Chapter 1, General Provisions, Article 211. The father and mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. That's it. I'll read that part right there again. In case of disagreement, the father's decision shall prevail unless there is a judicial order to the contrary. Now, there's no penalties under Philippine law to penalize a mother who does as she wants, even if she disagrees with the father. As a matter of principle, as lawyers and a judge have explained to me in the Philippines, that's in there. it's law. The father's decision prevails if there's a disagreement with the mother. But there's really no way to enforce it. There's really no penalty for the mother to ignore it. But in terms of who's right, I guess, if you wanted to get down to it, father's decision would prevail. So if the mother wants to be a nasty, cheating woman and not want to share the kids, share custody, share anything, have reasonable conversations, technically the father in the Philippines can make a decision and it's final. As long as the kid's over 7, he can't. If the kid's under 7 years old, you can't separate the kid from the mother under their law. But above the age of 7, it's typically the kid's choice. But decisions regarding anything else, like where the kid goes to school, what you do medically for your kid, all those things, the father could overrule the mother's decision, according to the law. It's a waste of money, though, to try to enforce anything, pretty much, dealing with those people. So I'm going to go back to where I left off on this very, very distracted, all over the place attempt to present something. Okay. So wherefore that Julie is no longer present in the household where Abel is currently residing against my will, and he is no longer under her care or spending nights with her where she resides, which matters under American law when you're dealing with child support, because the kid has to be spending the night with the parent to be receiving support. And if the mother's not there, why is the mother receiving any support? Question mark. Therefore, it is not in accordance with the laws governing the eligibility for Julie to be receiving child support that she... I got another typo in here. Eligibility for Julie to be receiving child support that she continue to receive child support intended for the daily needs and care of Abel. I need to fix that grammar. 3. Whereas in accordance with Philippine law, and as no child custody order has been sought in the Philippines by the mother for sole or primary custody, which they don't really have in the Philippines, they call it parental authority. American law and Philippine law when it comes to kids, two different worlds almost. Parental authority, as is termed in the Philippines, of my son Abel, in accordance with the Family Code of the Philippines, joint parental authority of Abel remains between the mother and I, unless there is a judicial order to the contrary, which there is such an order in effect whenever I am present in the Philippines, where I was granted sole parental authority of Abel as per Section 1 of the Compromise Agreement that was entered into on January 15th of 2019 between the mother and I, after the filing of a writ of habeas corpus with the Court of Appeals in Cebu City, Philippines. After Julie had kidnapped Abel, and she also kidnapped the little brother, Alex, who are both legally my kids in the Philippines, and I have a right as a father. I have joint parental authority over them. Not that she respects it, not that she cares, because there's no accountability with that, really. And you're just throwing money away to take them to court about. But I've thrown some money away. Just to tell you, I've thrown some money away. Where I was granted sole parental authority of Abel as per Section 1 of the Compromise Agreement that was entered into on January 15th of 2019 between the mother and I, after filing a writ of habeas corpus with the Court of Appeals in Cebu City, Philippines, after Julie kidnapped Abel and disappeared for a very notable duration of the 2 months I was in the Philippines to visit and spend time with him. The outcome of the hearing was that a compromise agreement was reached, granting myself full custody of Abel whenever I am in the Philippines. Yet no order within the compromise agreement or under Philippine laws deprives me or reduces any of my joint parental authority at any time whenever I am not in the Philippines or working elsewhere in the world. There's Nothing in there that takes your parental authority as a father or a mother away from the kid, your kid. Even if the grandmother is taking care of the kid, you're the father or you're the mother, you have joint parental authority of your kid. Your decisions matter, even if you're not there. Technically, how the Philippine law works, if she's not there and I'm not there, her mother or my father, if my father was there, but my father doesn't live over there, any of my parents or her parents would then be able to exercise parental authority over the kid for the time. But nothing still takes away from my parental authority or the mother's parental authority. So if we're consulted, or we say we'd like this done, that would be what should be done under the law. But people follow the law there. A lot do, but a lot don't. Too many don't. Where was I? Yeah. Yet no order within the compromise agreement or under Philippine law deprives me or reduces any of my joint parental authority at any time whenever I am not in the Philippines or working elsewhere in the world. So the mother does not have any degree of parental authority over my son Abel that I myself do not have at any point in time. For the court to make an assumption that the mother has custody of Abel, so this is referring to the American court, making an assumption that the mother has custody of Abel that I do not jointly exercise at the same time is in direct conflict with Philippine law and the decision and order put into effect by the Court of Appeals in the Philippines where jurisdiction over my son Abel is had. So the kid's not in America, never been to America. The court's got no business making assumptions about any of this, which is what they did in 2016 during the support hearings. That I was unaware are actually voluntary, and you can simply say, I don't consent, I'm not contracting with you, and you put it in writing, obviously, and you don't show up to their hearings unless you're making a special appearance for jurisdictional challenges to say that, basically. I don't consent, you don't have jurisdiction. And then you can walk out the court, and they could cook up, although the problem is the courts do what they want. The judge thinks that she's a judge and not acting as a private third-party contractor, which is why when they deny you your demand for a trial by jury, as I tried, and the judge denied, the only reason they could deny you a trial by jury is if they weren't actually a court. There was a private hearing, actually, for a private third-party corporation known as Michigan Child Support, registered under the city of Lansing or something like that on this website, dnb.com, www.dnb.com is the website. You go search up any private corporation you can think of, and their name should show up in there if they're a registered corporation. Private corporation, not public corporations. Or so I don't think. I'll continue because I'm losing and confusing myself. This is just a nightmare presentation all over the place. Nothing makes any sense, probably. Good luck if you're still listening to this. Whereas I, Charles Walter Book IV, at no point willfully consented to or entered into a child support agreement with the court for the private for-profit Title 4D federal contractor entity, commonly known as the Friend of the Court for Child Support Services. No contract bearing my signature or consent to be compelled to support my son Abel through the third-party private corporation, commonly known as the Friend of the Court, exists. I probably need to look into these names a little bit more. This might need to be the private corporation, commonly known as Michigan Child Support. The point of this statement, though, is that no contract bearing my signature or consent to be compelled to support my son through them exists. Therefore, I must demand to know by what authority or contract the Friend of the Court claims that I am an obligor and obligated to pay the financial support for my son Abel through their unaccountable third-party process that I have never knowingly consented to or entered into agreement to be a participant of. I'm making the claim that it's an unaccountable third-party process because there's no system of accountability when you're dealing with this in the Philippines. It is absolutely an unaccountable process with a non-reciprocating country. It's not part of the Hague Convention. There's nothing in place judicially, legally, or process-wise for them to phone them up and say, hey, is the kid okay? There's no one over there. They can't hold any of it accountable. They could call up the embassy maybe, and the embassy could call and ask about the kid. See, the embassy has no authority, no jurisdiction. And do you think the court in America is going to spend any money, any at all, to try any kind of legal process in the Philippines, in a non-reciprocating country in general, to try and do anything? No, it's not profitable. They just be throwing money away. They'll let you throw your money away on the process, but they're not going to throw their money away on the process. The courts are acting like companies, only doing what is profitable and makes them money. Lawyers do the same stuff. If it's too hard for them, they don't want the cases, which is what I dealt with in 2016 and what I dealt with when I just tried and talked to a lawyer earlier today. He's like, it's a shit show, and it would cost $15,000 for me to fix anything, and I'd have to go to the Court of Appeals, and I'm just not interested in it. So even you reach out to a lawyer, these characters don't want to help you because it'll be too hard. And you're not going to get any of your money back with how this wonderful system probably works, though some claim to have gotten their money back. The Alman Osiris claims he can get money back. I'm not sure how they're going to get money back from my ex-wife, who's not in the country, who's in the Philippines. Well, no, she's not in the Philippines. She's in Germany, but I don't know if the court knows that or cares about that. All the money's gone to the Philippines. I don't think they're getting anything back. Good luck. I mean, I'll have to go after the corrupt official, the judge, Judge Janice M. Burgess, and sue her personally, which is going to be a whole nother fight because to my understanding, they're going to try to claim they have judicial immunity, though they operated beyond their jurisdiction. So how constitutional law works, once you're operating beyond the Constitution, or outside the limits of your oath of office, you have it. Your job in the government has a limit to it. There are limits. And when you're outside that, you become liable. You don't have any kind of immunity anymore. You don't have official immunity. You don't have judicial immunity. Any of those immunities, they're all gone. The moment you do something you don't have the authority to be doing. With how American law and government works, I explain this. They created a constitution, which is a contract in writing, enforceable in law, between the government and the people. Government said, we're going to govern this way. And the people said, okay, that's your limits, though. You can't do more than that unless we amend the Constitution, unless we change the contract to give you powers you didn't have before. We give you the powers because the power is vested in the people. It's from the people. And you created a constitution, which was the contract, which allowed the government to do their job. If it's not in the contract, they don't have the power. They can't do it, and they can't go write themselves up more powers. You'd have to amend the Constitution to give themselves more powers that they don't have because there's no contract giving it to them. They don't have it, period. Constitution, so Congress, for Michigan, for example, and most of the states out west, you have the Northwest Ordinance. And under that, the state of Michigan was created after they had so many people, such a population, and such a landmass size, etc. They formed a state, and that state, so Michigan, had a constitutional convention, and they drew up a Michigan Constitution, which is subsidiary to the federal level. So the United States Constitution, I'll be more correct about this. The United States of America, not the all capital letters United States, a corporation. The United States of America, Constitution of the United States of America. Under that, they issued the Northwest Ordinance, an act passed by Congress, and that allowed for the formation of the Union State of Michigan. Same thing with Ohio, Illinois, Indiana, Wisconsin, Minnesota, all the way out to Alaska. Michigan has a constitution. Same with all the other states. They have a constitution. Again, it is a contract in writing, enforceable in a court of law, and it sets the limits of what government can do. If the powers aren't in there, the people didn't give it to the government to have the power to do that. All other powers are reserved to the people. And under that constitution, it creates the various branches of government: the executive branch, legislative branch, judicial branch. And they have their limits clearly spelled out in there. They can define some things, but what should be done in order to change the things to the degree they have changed is you would have to have amended the Constitution to give them powers to do the kind of crap they're getting away with. Like, they can't compel you to do anything against your will. That's the basis of American law, government. You know, we're a free country with a free people, and if you don't consent, it can't force you to do anything. I guess unless you engaged in a criminal act where you violated someone else's rights and they have a right to seek a remedy for the damages you've done to them, where there's an injured party. If there's not an injured party, they can't compel you to do a goddamn thing. With how our laws work, with how they were meant to work by the people who wrote up the laws. That is the intent of the people who wrote up the laws that founded our country. Not for tyranny, but for freedom. Government is there to protect our rights, to protect our freedoms, and not to violate them, not to do as they want, not to cook up whatever laws they want to force you to do anything. Wear stupid masks, for example. Have zoning ordinances tell you what you have to do with your lawn. I could let it go to seed if I want. Why should I go buy grass seeds? Why not just let my grass grow, get seeds out of them, spread the seeds all over the lawn, and maybe I'll cut the grass then, or I'll bring in a goat. Can't compel me to go buy a lawnmower from Home Depot and mow my lawn. Not that I have a lawn to mow. And there's no Home Depot around here anyway, so. Done with that rant. We'll digress and we'll go back. I forget if I even covered everything I was trying to explain right there. So the power to govern comes from the consent of the governed, what I was just explaining right there. And I do not and have never consented in this matter regarding to going to court and having child support and starting the whole process. The whole time in court, I disagreed with it. The whole time in court, I challenged it. Very adamantly. I even have the transcript of it. Maybe I'll read it sometime for fun. Post a video about it so everyone can know what Judge Janice Burgess is like when you go to court against this nasty old bigoted lady. Man-hater. Total man-hater. You could tell. She didn't care anything I had to say. They just wanted to get right to support. Let's talk about money. Because they're a business. They only want to make money. They don't want to waste time talking about jurisdiction because they're not making money when they're spending their time doing that. I do not consent to pay support for my son, Abel, through the third-party services of the Title 4D contractor agency, and any and all money collected or paid has been through wrongful means or the wrongful threat under the color of law without actually being law, and was paid, when paid, was paid under duress, You got to specify that when if they're forcing you to do something and you don't want to do it, it's under duress, no matter what it is, and they can't hold that action against you when you do it under duress. So if they threaten to arrest you and you're stuck up in this whole stupid legal process dealing with friend of the court, and you have to write checks just to keep the value under whatever the number is, they'll actually go issue a warrant and come arrest you. Make sure to sign every check under duress. I've done it. I've signed checks and I always write under duress and then I mail it in. They seem to get cashed somehow. Banks should know better than that, but tells you your bank's not reading the checks. When you write under duress, they shouldn't be allowing the checks to cash. They think, oh, you sent us a check, you're consenting to the process. If you don't write under duress, they think they operate under implied consent. Like, oh, he sent the check, that means he consents. Like, no, you threatened to arrest me. You threatened to take my license. You threatened to take my passport that I need to go out of the country, to travel to the Philippines, to go see my kid. You think I want to write this goddamn check to people? I'd rather take care of my kid myself as a grown adult, which I did from when he was born, until the stupid process started and the mother cut contact with me. But she cut contact with me for a year and a half before the process started. Starting the process actually kind of compelled her to let me talk to him now and then. Dirty stuff, no accountability. The court didn't care about that either. Like, oh, so what, they use dirty tactics? We don't care. We're only here to discuss support. We're only here to discuss support. Oh, you want to talk about custody? Nope, we're only here to discuss support. They only want to talk about money. And they would claim it's because, oh, that's what the case is about. That's the only thing we have jurisdiction to discuss. They don't actually have jurisdiction to even do it unless you consent to it, supposedly, which you've probably never done. You probably never signed a contract agreeing to any of this stuff. They operate under implied consent. Whenever you talk to them on the phone, tell them I'm not contracting with you and I don't consent to this process. You have to explain process to me, though, because they're a government office. And when you're dealing with a government office, when you're dealing with sending them anything in the mail, or knowing how the government office even works for you to be able to do things the way the government office needs it done so you can communicate to them. Like, they have to explain that to you. That doesn't mean that you're contracting. It doesn't mean you're consenting to the process by asking them, this is what you're doing. How do I reply to it? Do you want it in a letter? What's the address? Who am I sending it to? That's explaining process. And just because you're asking that to them does not mean that you're consenting to their stupid process. That the whole thing has got to this dark, nightmarish state where you have to explain to them that you don't consent to it, and they try to assume that you consent to it because you're talking with them, is just crooked and corrupt and as ugly as the whole thing gets. And the people knowingly and willfully engaged in this, though most of them probably are freaking oblivious. They have no clue how law even works. They were hired, they got a job, they just want a paycheck to support themselves, their family, whatever, and they're just doing what they're told. Most cops are just doing what they're told. They don't bother to read the laws. IRS agents probably don't bother to read the laws. Child support agents probably don't read the laws and even understand what they're doing, or the details of what it even is that they're doing, or what gives them the authority to do what they're doing. And they think, oh, I can just send you threatening things in the mail, threatening to arrest you or take away your license, your passport, etc., and compel you to show up in court, when it's federal mail fraud. Under Title 18, section, I can get to that later on in this one, 400 and something. So I didn't make it very far this last time trying to read this. Power of the government comes with consent of the governed, and I do not and have never consented in this matter. I do not consent to pay support for my son Abel through the third-party service of the Title 40 contractor agency, and any and all money collected or paid has been through wrongful means or under threat under the color of law without actually being law. Positive law is what I should say. Positive law. Things have to be positive law in order to positive law. A law that they can take you to court for or enforce against you. Because if it's not positive law, see, it has to have been passed by Congress. It has to have been signed by an executive official, like a governor or a president. It has to have been reviewed by a judge for the constitutionality of the law that was passed. And then it has to be posted in the Federal Register or the Michigan Compile Laws Act, for example. It has to be posted for the public to be able to see it and read it and know it's a law. If those 4 steps were not done, then it's not a law. It's not positive law. They can't, if you didn't know it was a law, and the process to make it a law as the Constitution requires it to be done to make laws, then it's not a law. It could be some sort of administrative procedure or process, but you'd only be subject to that if you were an employee of the corporation, like United States Corporation or the state of Michigan Corporation, or whatever your county body corporate, as the the 4th revision of the Michigan Constitution says that all counties shall be body corporate, or however it's wrote. All cities they're body corporate. They're a corporation. They're an artificial entity, a corporation. They're not a sovereign governmental entity. It's a corporation that receives its right to be from the corporation above it, being the state or the federal government. So it was paid under color of law without actually being positive law, and when paid, is paid under duress. No different than paying a thief threatening to take your livelihood, driver's license, or passport that is needed for daily life and international travel to be present in the life of my son, able outside the United States of America. They revoked my passport. They would prevent me from going to see my kid. They revoked my driver's license. Not that I'm required to have a driver's license to drive a car. Chicago versus Motor Coach, Supreme Court decision, and many other ones. I have a long list of those. If you would like a copy of those, just ask me and I'll email them to you. Say you don't need a license to drive a car. Use your personal property on the highways and byways. You have a right, constitutionally secured right to travel. You just got constitutionally secured rights to use public highways and byways. And you can take your personal property on it. To engage in business on it, that may be questionable. If you're being paid to drive a semi-truck, a large commercial vehicle for a company, maybe they could require you to have a commercial driver's license, but there's still the argument that you get a right to work, to contract your time, your labor, and your skill as you see fit. And that can't be converted into a right and a privilege, a license and a fee issued for the exercise of it, in accordance with United States Supreme Court decision in Murdoch versus Pennsylvania. And if they did convert your right into a privilege and issue a license and a fee for it, you can engage in the act with impunity. According to Shuttlesworth versus Birmingham, Alabama, another United States Supreme Court case. So even if they tried to convert your right to work into a privilege and issue a license and a fee for it, you can do it. You can engage in it, and they can't punish you for it. They may try because they're ignorant as hell. They don't know any of this stuff. There's so much crap in our legal system. Just to be able to have read all the laws and to have reviewed all the Supreme Court cases, lower court cases, and every decision that was ever made in the whole process. No one has time in life to do that. We live in a system that is so bloated, would be the good word to say it, that no one could ever understand all of what's going on in order to comply with every law and every ruling and understand every nuance, every little bit of how every component in law and life is supposed to work under the system. No one can do it. Even a team of lawyers could never comb, and you don't even need to be a lawyer to be able to practice law. That's another right. You have a right. And if you know something and you have knowledge of something, you have a right to work. You have a right to contract your time or labor and your skill as you see fit. Michigan's a right to work state. Does the government respect that? No. They want to make money and they want to control who gets to do what. See, if people who weren't members of the Michigan Bar Association or the American Bar Association, which answers to the Bar of London, which answers to the Crown of London, which tells you that a private foreign entity has a controlling influence in our entire legal process and has control of our entire judicial branch and most of the legislative and executive branches, because all those people are lawyers before they become congressmen, politicians. Maybe they're businessmen, but they're people who have some sort of license or have had to pass some kind of board exam here or there or get a college degree. Usually they have college degrees. It means that they had to drink the Kool-Aid. They had to drink the college propaganda fed Kool-Aid in order to get to where they are in life. And so you have a control of the people who get to even be in power, which is a serious problem. The benevolent understanding of why that is the way is because you want competent people to be the ones in offices, competent judges who are aware of things to be judges. They'd have to be licensed to practice law, as the Michigan Constitution, Article 6, Section 19, states that all judges and justices in the state of Michigan are required to be licensed to practice law. Not that the state licenses any judges or justices, because they don't have licenses. They have bar numbers, because they're a member of the Michigan Bar Association, a private third-party, non-governmental entity, which isn't a license, because only the state has the authority to issue a license, which is a power or privilege to do something you didn't have the ability to do without it. Though everyone does have a right to contract their time, their labor, and skill as they see fit. So if you know how to do law, you know what laws are and how to practice law, they can't really require you have a license for it. But our Constitution does require all judges and justices are licensed to be practicing law, which none of them are, because the state of Michigan doesn't issue licenses. I asked Judge Burgess to see her license in the hearing back in 2016, and she glared at me and refused because she didn't have a license. None of them have licenses. They don't like it when they're asked questions like that, or demanded. You have a right to know that you're in a court of record. All courts of record shall have judges and justices of courts of record shall have a license to practice law, is how it's phrased there in Section 19, Article 6, Michigan Constitution. Let's put all those backwards, and then you have the proper arrangement. So I'm going to try to continue here. 5. This is the long section, and I'm going to try to just read this one straight without adding too much commentary, because I include all the arguments in it. Whereas, let us review subject matter jurisdiction and void judgments. Void judgments are those rendered by a court which lacked jurisdiction, either the subject matter or the parties. In the case of Weil versus Round Valley Bank, 38, Arizona, 411. 300, page 955, year of 1931. The Tube City Mining and Milling Company versus Otterson, 16, Arizona, 305, 146p, 203, 1914. And Milken versus Meyer, 311, USC, US, so United States Supreme Court, 457, 61S, CT, 339, 85L, ED, 2nd to 78, 1940. I haven't figured out all the magic how to read where these Supreme Court cases are, but if you get how it's spelled and you type it into a search engine, you usually get the case. You've got a PDF of it if there's one online. Summary of law of voids. Before a court, or a judge in parentheses, can proceed judicially, jurisdiction must be complete, consisting of 2 opposing parties, not their attorneys. Although attorneys can enter an appearance on behalf of a party, only the parties can testify, and until the plaintiff testifies, the court has no basis upon which to rule judicially. And the 2 halves of subject matter jurisdiction equals the statutory or common law authority the action is brought under, the theory of indemnity. and the testimony of a competent fact witness regarding the injury, the cause of action, if there is no jurisdictional failing, if there is a jurisdictional failing appearing on the face of the record, the matter is void, subject to vacation with damages, and can never be time barred. Subject matter jurisdiction was never had by the Michigan 32nd Judicial Circuit Court in Ontonagon to move forward with the proceedings of either the May or August 2016 hearings. Firstly, because the plaintiff never made an appearance, my ex-wife Julie, even when I called her to the witness stand to testify, as was my right to face my accuser in accordance with the Bill of Rights, and yet the court proceeded as if it was not required because a child support specialist who spoke over the phone with her was present, and the court pretended that that was an acceptable substitute for the actual plaintiff who applied for child support. I was denied my right to face my accuser. Subject matter jurisdiction can never be presumed, never be waived, and cannot be constructed even by mutual consent of the parties. Personal jurisdiction, for example, ? Subject matter is two-part. 1, statutory or common law authority for the court to hear the case, and 2, the appearance and testimony of a competent fact witness. In other words, sufficiency of pleadings. Even if a court or its judge has or appears to have subject matter jurisdiction, subject matter can be lost. Major reasons why subject matter jurisdiction is lost in regards to this case. A, fraud committed in the procurement of jurisdiction. Friedman Brothers versus Furniture. B, Department of Revenue, 109, Illinois, 2nd 202, 486, and E, 2nd 893, year of 1985. B, fraud committed or fraud upon the court in Village of Willowbrook, 37, Illinois, a appellate 3rd, 393, year of 1962. C, when the judge is involved in a scheme of bribery. That deals with federal incentive funds being laundered to the court system for having child support orders in place and collecting on them, which means that they're incentivized to have support orders and to collect on them. Super sus right there. D, violation of due process. Johnson versus Burt, 304 U.S. 488, 458, 58 SCT, 1090 or 1019. Pure Oil Company versus City of Northlake, 10 Illinois, 2nd, 241, 245. And Halgerg versus Goldblatt Rose, 363 Illinois, 2nd, year of 1936. And E, if the court exceeded its statutory authority. Rosenstein versus Rosenstein, 278 V supplemental, 794 SDNY 1967. These are the 5 things I'm citing that apply to this case. Regarding A, B, and C, fraud was committed both by Ontonagon County and Keweenaw County friend of the court, which are Title 4D agencies, using threats by UPS mail under the color of law of arrest, suspension of license and or passport, and adverse credit reporting, committing crimes of stalking, aggravated harassment, and scheme to defraud by mail fraud. Under 18 U.S.C. Section 1341. If I did not appear for or consent to participate in legal process for the application for the child support services by Title 4D agency, a private for-profit federal contractor agency, unconstitutionally operating beyond the 10 miles square of the District of Columbia, because that's what the Constitution allows the federal government to operate within. They're for settling matters between the states, protecting the rights of the people, in all the states, not operating in the states for their own ambitions, but for protecting the rights of the people, which is what you'd be doing through a court. Or that's why you appeal up to the Supreme Court or to federal court. When your state doesn't want to follow the laws, you go file in federal court, and they're there to protect your rights, is what it's supposed to be for. And then they deal with international matters. Where was I? So if I did not appear for or consent to participate in a legal process for the application of the Child Support Services by Title 40 agency, a private for-profit federal contractor agency unconstitutionally operating beyond the 10-mile square of the District of Columbia, it's essentially a dirty workaround used by the government to trick sovereign-born men and women into implied consent to use the Title 40 financial services. And even if you clearly do not consent, which I have done many times, the Title 40 agency still pretends they didn't hear it or read it on paper so they can claim you have your implied consent. Dealing with dirty tricksters who seem to fill the government offices, which is a serious problem we got going on. 18 USC, section 1341, whoever having devised or intended to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses, represents or promises or to sell, dispose of, loan, exchange, alter, give away, distribute, supply, or furnish, or produce for unlawful use any counterfeit or spurious coin, obligation, security, or other article, or anything represented to be or intimidated or held out to be such counterfeit or imitated, or held out to be such counterfeit or spurious article for the purpose of executing such scheme or artifice or attempting so to do, places in any post office or authorized depository for mail matter, any matter or thing, whatever to be sent or delivered by the post office, or deposit or cause to be deposited, any matter of thing, whatever, to be sent or delivered by any private or commercial interstate carrier, or takes or receives therefrom any such matter or thing, or knowingly causes to be delivered by mail or such carrier according to the direction thereon, or at the place at which it is directed to be delivered by the person to whom it is addressed, any such matter or thing shall be fined under this title or imprisoned not more than 20 years or both. 442 U.S.C. subsection 659, 5, the term legal process means any writ, order, summons, or other similar process in the nature of garnishment. A, which is issued by a court or an administrative agency of component jurisdiction in any state, territory, or possession of the United States. Furthermore, regarding D and E, when in the August 2016 hearing, I demanded by a trial by jury. And Janice M. Burgess, a pretend judge during that hearing as an acting clerk for the Title 40 agency, renting the courtroom, being nothing more than an undersigned jurist with a degree in law, refused to present me with her license to practice law when I demanded to see it to ensure I was in a court of record with an actual judge as required by Michigan Constitution Article 6, Section 19, Clause 1. Section 19(1), the Supreme Court and Courts of Appeals, the Circuit Court, the Probate Court, and other courts designated as such by the legislator shall be courts of record, and each shall have a common seal. Justices and judges of courts of record must be persons who are licensed to practice law in the state. So I continue. A violation of due process occurred when Janice M. Burgess denied my constitutionally secured right to a trial by jury of my peers, a direct violation of the supreme laws of the land, established by the Constitution of the United States of America, Article 6, second paragraph, the Supremacy Clause. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges of every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding, meaning it has no standing in law if it is in conflict with the Constitution or the constitutions of the states. Found in the 7th Amendment of the Bill of Rights of the Constitution of the United States of America, in suits at common law, where the value and controversy shall exceed $20, the right of a trial by jury shall be preserved, as well as the Constitution of Michigan of 1963, which is the 4th revision, Article 1, Declaration of Rights, Section 14, jury trials. The right of a trial by jury shall remain, but shall be waived in all civil cases unless demanded by one of the parties, which I did, in the manner prescribed by law. In all civil cases tried by 12 jurors, a verdict shall be received when 10 jurors agree. In this instance alone, when my demand for a trial by jury was denied, any claim to subject matter jurisdiction the court could have had was lost, and all preceding judgments made by the court and any courts entered on account of those judgments by the court or a 4D contractor agency to enforce them have been without a doubt void orders based upon a void judgment or based upon void judgments. For anything that is in conflict with the Constitution, the supreme law of the land, is notwithstanding in law. C. Marbury versus Madison, 5 U.S. 137, the year 1803. And I quote from this case, "No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical. For certain, the supreme law would prevail over all other laws. And certainly our forefathers had intended that the supreme law would be the basis of all law. And for any law to come in conflict would be null and void of law. It would hold no power to enforce. It would hold no obligation to obey. It would purport to settle as if it had never existed. For unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a near nullity or a fiction of law. If any state within any law which is passed is unconstitutional, the whole law is unconstitutional." Also see Miranda versus Arizona, 384 U.S. 436, year 1966. Where rights secured by the Constitution are involved, there can be no rule or lawmaking or legislation which would abrogate or abolish them. End quote. And then I continue on with my argument. Nor is the assertion of federally secured rights under the Constitution of the United States of America to be defeated by any state or its courts under local practice, policy, or procedure. See Davis versus Welchler, 263 U.S. 22 at 24. Quote, "The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice." End quote. That means if you have a constitutionally secured federal right and the state cooks up a law and claims they can do something that would violate one of those rights, the Constitution prevails. Your federally secured, protected right by the Constitution, which protects it, would prevail over any weird little thing that your state, your county, your township wants to cook up and claim as a law, and they can tell you to do it. Pretty plain and simple right there how that works. You have a right protected by the highest law in the land. It's protected by the highest law in the land. All the lower laws are all subject to it, and if they're in conflict, they're null and void. They ain't law. They purport to settle as if they never existed, not from the time so branded in an open court, but from the inception of the law. From when it was even passed, it wasn't law. Then I continue, in any such statute, local practice, policy, or proceeding claiming to do so is null and void. A procedure is null and void. See Bertaldo versus California, 110 U.S. 516, where the U.S. Supreme Court clearly states very plainly, quote, "The state cannot diminish the rights of the people," end quote. Meaning they can't make laws or policies or practices or procedures that would diminish any rights you have. They can't take away your rights. They can't limit your rights. They can't take your right to something and trim it down to be a very small thing and not the whole right. They can't say, oh, you can have a gun if you have a license. No. You have a right to have a gun. That's Second Amendment. That is a protected, constantly secured right. Pretty plain and simple. The right to freedom of the press, freedom of speech, peaceful assembly shall not be abridged, meaning you can't slim it down. You can't diminish the rights of the people. Plain and simple English there. You have to be an evil, schemy bastard to be looking for anything other than that. Trying to manipulate people, control people, trying to implement a system of tyranny for control because you do not respect and probably don't understand what freedom is really all about. And freedom is a two-edged sword, but we're a free nation. That's what America is all about. No questions, ifs, ands, or buts. That is what America is about. That is what it was founded for. That was the intent of the founding fathers who wrote the laws that established it. That is what it has to be interpreted by. And no modern judge gets to change that because they don't like something. If you don't like it, you need to have a constitutional convention and rewrite the Constitution. You have to modify the supreme law if you don't like it. And that's going to take a majority of the people in the states to do it. Are we locked into a bureaucracy with such a system? Sadly, yes. You can't just go change laws, but also positively, yes. You're not going to just go take away your rights. They can't unless they modified the Constitution and struck the amendments right from it. So that if they added an amendment and they struck sections from it, through a constitutional convention where they rewrote the whole thing, not just adding amendments, you're rewriting the whole thing in order to take something out of it. And okay, so Norton versus Shelby County, 118 U.S. 425, 1886. Unconstitutional act is not law. It confers no right. It imposes no duties. It affords no protections. It creates no office. It is in legal contemplation as inoperative as though it was never passed. Bennett versus Boggs, 1 BALDW, 60. Statutes that violate the plain and obvious principles of common right and common reason are null and void. Pretty plain English right there. Now I assert, in the very same way the United States Supreme Court did, it is the obligation and duty of the courts and their judges to uphold and be watchful for the constitutional rights of the American people. See Briers versus United States 273 U.S. 28, year of 1927. Constitutional provisions where security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachment therein. Pretty plain and simple. Boyd versus United States, 116 U.S. 616, 1886. The court is to protect against the encroachment of constitutionally or secured liberty. Constitutionality or secured liberty. It's the job of the court to protect. That is what the court is there to do. That Supreme Court said that is your duty as a court. Judge who doesn't want to do that is, well, going to lose the case when you go file an appeal. And you cite that, Boyd versus United States, 116 U.S. 616. Then I continue, and where a law, such as a constitutionally secured right, is plainly written, the courts are not at liberty to interpret the laws any other way than how it is written. See 16M Jurisprudence, 2nd edition, section 117. Various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provisions in question is clear and unambiguous. In such a case, the courts must apply the terms of the conditions as written, and they are not at liberty to search for meanings beyond the instrument. That's referring to modern judges and politicians trying to claim words mean things they didn't used to mean. You can't go make all these weird stretches to try to change what a law means to suit your interests. The law was written, the guys who wrote it, how they intended it is what it should be interpreted as. And if it says it in plain English, it's plain English. There's no working around it. They don't get to do that. If they don't like the law, have a convention, rewrite the whole law. Which you probably need to do. We have a whole new, to get rid of all the crap, all the bloat in our system, we need to have a convention and rewrite the whole gosh darn thing. And if we need to divide the country into an East and a West where the socialists and the psychos can do things the way that they want with totalitarianism, let them go move there and do that. And let another part of the country live free, unrestricted lives, all the bullets, blades you want. And if everyone's well armed, we ain't going to mess with each other. We're not going to go shoot up places if everyone's got a gun, and you're going to get shot if you try that stupid stuff. And the courts and their judges must adhere to the Constitution and obey all provisions within it. I forgot the in. Regardless of the opinions of the court or any other elected official in any office having any degree of influence over public opinion or official conduct, process, policy, and procedure. Am Jurisprudence, 16 Am Jurisprudence, 2nd edition, section 155. Since the Constitution is intended for the observation of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, its courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty. There is spelled incorrectly. There with an I. In authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinions as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Means it doesn't matter how much it's going to cost the courts to not be profitable, to be constitutional. They're paid with public funds, tax dollars from business and everything else, and everyone who's entered into a contract and declared themselves to have a liability and pay the IRS their money that they're probably not actually liable to pay if you're just working. If you're a business, yeah, you're covered under the taxes. Individual, if you've signed the contract and declared yourself liable, yeah, you become liable for that year. Just don't do it again the next year if you don't want to pay a tax you're not liable for, unless you want to support your state. or the federal government, but I shade away from the federal government as long as they're going to keep engaging in foreign aid, where they support and prop up dictatorships, or they go engage in military campaigns and go blow up brown people, because they're really a bunch of racists up there pretending to not be, but they are. Brown people are only good for voting for them so they can keep staying in office. That's the only interest of the politicians with brown people, is to keep them voting for them so they can stay in office. The real racists are the ones in government, the ones wearing suits and ties, not the average white boy with a red neck and a funny looking hat. We're not real racists. Married to a Filipino, for God's sake. Filipina. Was married. Have a half Filipino kid. Not a racist. Not a real racist at all. I'm gonna continue. I interrupted myself in the quote. Not a good idea. Okay, so I will continue. 16 Jurisprudence, second edition, section 155. Thus it is said that the courts shall be on alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise in accordance with these basic principles. The rule is fixed that the duty in proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment is drawn into question. If the Constitution prescribes one rule and the statute another in a different rule, it is the duty of the courts to declare that the Constitution and not the statutes governing in cases before them for judgment. In case not the statutes governs in cases before them for judgment. Well, that's the quote out of the book. I didn't write it. That means if you can, so the statutes that cooked up the child support stuff, Title 42, U.S. Code, if they're unconstitutional because they're compelling you to do something, unless they're actually not compelling you because it's a voluntary process, which is the only way they can get away with such shenanigans, is they have to make it voluntary. But they deceive you and threaten you if you don't comply, if you don't consent to sign a W-4 contract with the IRS, if you don't consent to child support proceedings, establish paternity, and consent to their services, take your money directly out of your paycheck, which they can only do to federal employees, by the way. They can't just go out and do that to anybody, but they get away with it. Okay, so that's kind of the end of the argument, but I have a statement to the court that I've included in this, which I don't know how this will be received. I'm sure I'll aggravate a judge, which is all you can really do at some point when they stop listening to you. Statement to the court that is not to be ignored. As you have no judicial or official immunity when you operate outside the supreme law of the land, the Constitution, and the clear limitations of your offices within constitutional limits, and have then become liable for damages when you operate beyond those constitutional limits, and you will, at some point, by someone with the will to see it through to the end, get sued and stuck with the bill for all the costs and damages to make this very unconstitutional, quote, legal and culturally brainwashed to be acceptable nightmare of a support system right, or at least as right as it can be made with how much damage has been done over the decades. Simply because it has become the norm for the courts, state, and federal agencies to engage in shadowy workaround through unelected officials within administrative agencies such as a private for-profit Title 40 agency listed on the Dun & Bradstreet website as a private corporation, Michigan Child Support, federally contracted through single and separate organizational units operating beyond the federal jurisdiction of the 10 miles square of the District of Columbia and the states of the Union, claiming to have jurisdiction in child support matters for having been given the responsibility for administering or supervising the administration of the various state plans under Title 4D, Section 651 through 669B, and the Uniform Interstate Family Support Act. That could only be described as a professional, organized criminal syndicate dressed, acting, and even believing themselves to be government officials engaging in misconduct with the violation of and flat-out neglect of constitutionally secured rights of the American people, all done under the color of law with magical implied consent for their other victims. Without being positive law and in clear violation of the Constitution of the United States of America, depriving Americans of life, liberty, and property without due process of law, all done with the use of public servants, such as county and state police and judges, paid with public funds to harass, threaten, coerce, even arrest with unlawful warrants. Michigan Constitution, Article 1, Section 21, imprisonment for debt. We don't have imprisonment for debt in Michigan. Our Constitution clearly states we don't. Based on void judgments and destroy the lives and financial well-being of those and their families, who seem to always be men, who do not willingly comply with the demand of and unlawfully and willfully consent to contract with and use the financial services of a Title 40 agency. This wicked trend by the courts and administrative agencies that has occurred for decades now does not justify continuing in any such practices, which are an abuse of power by the courts to enforce void judgments and void orders to collect money from hardworking Americans to sift off an administrative processing fee, and more importantly, to launder the federal funding under Title 42 USC Section 658A to the courts and their respective Title 40 agencies as any child support order issued by a state judge or any decision which may affect Title 40 incentive funds that will be deposited into the state treasury to reinvest funds used by the state to carry out the state plan, which makes it quite clear that the Title 40 agency exists primarily to fund itself and pay its employees to do bureaucratic jobs of very little value to the society, but great value to the people working for the agencies, as it is financially incentivized to implement and collect on support orders. How corrupt can a government agency get, I ask? Question mark. Whether the financial theft of the fruits of men's and occasionally women's labor, an occasional woman's labor, an unaccountable, misallocation of their earnings is perpetrated by the courts and the officials of the Title 40 agency, knowingly or in ignorance, is without excuse for any of it to continue in any manner. All of these practices and threats made under the color of law by the private 4D agency, with the help of the courts, must be ordered to cease and desist. And any judge with a brain and an awareness of this absolute fraud the courts are being used to perpetrate would throw every one of these Title 4D child support agencies and attempts to prosecute, to establish a support order by yet another bunch of public servants, the county prosecutors, right out. Such a judge with a brain and a conscience should instead order a disputing mother and father to attend some counseling to learn to civilly discuss the financial needs of their children, like any grown man or woman of legal age should be able to do. If the mother and father have not even had a discussion about it, there's no basis to immediately involve a private, for-profit, third-party collection service to involuntarily force people to pay them a processing fee or rely on their calculations for what is needed to provide for and raise the child specific to each family situation. And absolutely no basis to threaten to arrest or revoke licenses or passports required to work and earn a living to provide for and travel to see one's loved ones and engage in daily living in today's society. County prosecutors should be getting directed to prosecute Title 40 criminals engaged in fraud under the color of law through the use of the U.S. Postal Service, committing mail fraud under 18 U.S.C. Section 1341, while pretending and claiming to be government officials engaged in official duties. And the county prosecutors also need to be getting prosecuted for the role in the whole fraudulent scam. And the judges and prosecutors who have knowingly done this belong in jail. And all parties involved with the Title 40 agency and the procurement of federal incentive funds to run their crime syndicates should be proportionally splitting the bill for the costs and damages that have been stolen from men and women frauded into participating into the legal process. End of my statement. Prayer for relief. I, Charles Walter Brooke IV, do humbly pray the court for the lawful and just relief. 6, that my son Abel is no longer in the physical care of his mother, Julie, or spending nights where she is domiciled for an indeterminate amount of time. Julie is no longer eligible to continue receiving child support in accordance with the laws governing the state plan for child support. Therefore, the existing child support order must be terminated, as Julie is no longer eligible to continue receiving the support money intended for Abel. Well, she was never eligible for it because she doesn't have custody in the Philippines. We have joint custody, always, even if we're apart. Even if she's been cheating on me since 2013 or whatever it was. Long time. Even if we're divorced in America now, since 2020, we still have joint custody of the children in the Philippines. And there's already stuff in there for how to handle support in the Philippines. All it takes is communicating, but some people who are guilt-ridden, wicked, selfish people who can't face you because they've done so many wrongs to you don't want to have conversations, and they look for workarounds to try to steal your money without having to talk to you. Absolutely disgusting. Terrible example for children to grow up seeing their parents do also. Shouldn't even be tolerated by courts. Courts should take the context of the family situation, into consideration when deciding what to do with a court order. In the Philippines, in Philippine Family Code, it clearly says the guilty party pays support. If there's such a guilty party in a breakup or a broken family, the guilty party. Let me go down to that one. I'll read that one to you. I'll just read Executive Order number 209, the Family Code of the Philippines. Title 8, Support. Article 194, support comprises everything indispensable for sustenance, dwelling, clothing, medical attention, education, and transportation in keeping with the financial capacity of the family. In keeping with the financial capacity of the family. Not the support formula that the friend of the court cooks up to rob people and get their administrative cut out of it. I have no idea how much they even get over there. The money could all be disappearing and they could be getting less than what I am being robbed for. The education of the person entitled to be supported referred to in the preceding paragraph shall include his schooling or training for some profession, trade or vocation, even beyond the age of majority. Transportation shall include expenses in going to and from school or to and from places of work. This is even more draconian than the American support system, actually. Philippine support system is brutal. They rope everyone into this stuff. I'll get into this. Article 195, subject to the provisions of the succeeding articles, the following are obliged to support each other to the whole extent set forth in the preceding article. 1, spouses. 2, legitimate ascendants and descendants. 3, parents and their legitimate children and the legitimate and illegitimate children of the latter. Even the illegitimate children you have an obligation to support under Philippine law. If this woman wanted support money from me, she should have gone to the Philippine court, not the U.S. court. You could get even more out of me then. Parents and their illegitimate children and the legitimate and illegitimate children of the latter. So even your illegitimate children's illegitimate children, you have an obligation to take care of. legitimate brothers and sisters, whether of full or half blood. And then as a reference to section 291A, which I don't have on here. Article 196. Brothers and sisters not legitimately related, whether of full or half blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister being of age is due to cause imputable to the claimant's fault or negligence. Again, citing 291A. Article 197. In case of legitimate ascendants, descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimate or illegitimately related, only the separate property of the person obligated to give support shall be answerable, provided that in case the obligor has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support, which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or of the conjugal partnership. Article 198. During the proceedings for legal separation or for annulment of marriage and for declaration of nullity of marriage, the spouses and their children shall be supported from the properties of the absolute community or the conjugal partnership. After the final judgment granting the petition, the obligation of mutual support between the spouses ceases. However, in case of legal separation, the court may order that the guilty spouse, so if your spouse cheats on you and you're separate, the guilty spouse who cheated shall give support to the innocent one, specifying the terms of such order. See 292A. This is what courts should be looking at. They should be looking at who did the cheating, who left when the marriage was fixable, when you could have gone to counseling. If you just, I don't want to deal with you when you leave, when you steal the kids, that's a guilty spouse. That is dirty, guilty. And that a court is like, I'll just take the guy's money now. The woman took the kids and went off with some other guy. We make the guy pay the money while the woman is with the other guy, not married to him though, but still collecting the support money and living freaking well. That is the problem with the American court system. There is no context for what goes on in the family situation. It is strictly objective numbers and money. And that does not work. That is broken. If there is to be a support system, that is absolutely broken. There must be context. It must be looked at with detail. And we have to stop being no fault states. It's fault. Someone did something wrong somewhere that broke things, that broke the marriage down, that destroyed the family. And the person who did the breaking and did the damage is the guilty one. And you shouldn't ever be forcing the innocent one to pay for a goddamn thing. That's absolutely wrong. That's why people kill themselves. That's why my cousin Brian killed himself. Got drunk and drove down the road speeding. He was done with all the stupid stuff. Hit by a car, dead. Guy got out of support that way. Thank God. God bless his soul. Article 200. When the obligation to give support falls upon two or more persons, the payment of the same shall be divided between them in proportion to the resources of each. However, in case of urgent need and by special circumstances, the judge may order only one of them to furnish the support provisionally, without prejudice to his right to claim from the other obligators the share due from them. When two or more recipients at the same time claim support from one and the same person legally obliged to give it, shall the latter not have sufficient means to satisfy all claims. The order established in the preceding article shall be followed, unless the concurrent obligees should to the spouse and the child subject to parental authority, in which case the child shall be preferred. See 295A. It's a little confusing to me. Article 201, the amount of support in the cases referred to in Articles 195 and 196 shall be in proportion to the resources or means of the giver and the necessities of the recipient. In proportion. Not a formula the friend of the court cooks up based on your income, but based on what the person needs. If the kid don't cost that much to raise because your mom's taking care of them, their grandparents are taking care of them, or you're able to take care of them, you don't got to pay for a babysitter. You shouldn't be factoring child care into that too much. I mean, you're a parent. You're obligated to take care of your kid. Even your grandparents are obligated to take care of the grandkids under Philippine law. You don't need special formulas and extra money factored in there. What does the kid need? What does it cost to take care of the kid? That's what it costs. You don't need to have more, because then you're just enriching the person collecting the money with no accountability. 202, Article 202, support in the cases referred to in the preceding article shall be reduced or increased proportionally according to the reduction of or increase of the necessities of the recipient and the resources or means of the person obliged to furnish the same. Also see section 297A. Article 203, the obligation to give support shall be demandable from the time the person who has a right to receive the same needs it for maintenance, but it shall not be paid except for the date of judicial or extrajudicial demand. Support pendent, this is some Latin words right here. Support pendente lite may be claimed in accordance with the rules of court, Philippine court. Payment shall be made within the first 5 days of each corresponding month or when the recipient dies. His heirs shall not be obliged to return what he has received in advance. Article 204, the person obliged to give support shall have the option to fulfill the obligation either by paying the allowance fixed or by receiving and maintaining in the family dwelling the person who has a right to receive the support. The latter alternative cannot be availed of in case there is a moral or legal obstacle thereto. If you have to support someone, I'm going to read that one again. Article 204, the person obliged to give support shall have the option to fulfill the obligation either by paying the allowance fixed or by receiving and maintaining in the family dwelling the person who has a right to receive support. If you have to support your kid, you have a right to have the kid live with you, where you can take care of him or her. That makes so much sense. Oh, you have to support the kid. Well, doesn't need to be with the mother the whole time. Doesn't need to be with the father the whole time. If I have to support him, he should live with me and I take care of him. Duh. Oh, you don't want him to live with me. And there's no reason why he can't live with me. You just don't want him to live with me because you want to collect my money. Well, that's super sus. That shouldn't be allowed to happen. You want me to take care of the kid? I want to take care of my kids. Let them live with me. Is it that hard? No, you just want money is the thing. This woman just wants money. The latter alternative cannot be availed of in case there is a moral or legal obstacle thereto. That'd be the only reason you couldn't take care of the person you're required to support and have them live in your house. I'm not the one who was ever cheating in this nightmarish marriage I had. I can't see a moral reason why I would not be the one who could take care of my kid, but I absolutely could see a moral reason why she shouldn't be taking care of the kids if the courts simply took into context what happened that destroyed the family where we had to separate. Well, she just did her own thing, actually. There was no. I had to work, couldn't work in their country. I have to work in my country because that's where I can work to support them. And she did her own thing. Didn't want to come when the visa was done and just wanted my money. She's a greedy woman. Article 205. The right to receive support under this title, as well as any money or property obtained as such support, shall not be levied upon an attachment or execution. See Section 302A. Article 206. When, without the knowledge of the person obliged to give support, it is given by a stranger, the latter shall have a right to claim the same from the former, unless it appears that he gave it without intention of being reimbursed. So if someone has to support you, or you had a kid, you got a crappy parent, or a parent who doesn't want to take care of their kid, doesn't want to, is the words. That is not the case with my situation. I want to take care of my kids. And someone gives support to take care of the kid who's not the parent. The people who are obligated to take care of the kid have to pay the guy back, unless you gave it as a gift and didn't expect to get repaid. This is how draconian this Philippine support law gets compared to American law. And it's not that bad. I mean, this is not bad. It's just spelling out how you would normally deal with this in a family unit, taking care of your family. Like, does it really need to be written in law? I guess it needs to, or it is. Article 206. Nope, I did that one. Article 207. When the person obliged to support another unjustly refuses or fails to give support when urgently needed by the latter, any third party may furnish support to the needy individual with right of reimbursement from the person obliged to give support. This article shall particularly apply when the father or mother of a child under the age of majority unjustly refuses to support or fails to give support to the child when urgently needed. Any third party can furnish the money to take care of the kid in that case, and has a right to be reimbursed by the parent who doesn't want to take care of the kid. Article 208. In case of contractual support, or that given by will, the excess in amount beyond that required for legal support shall be subject to levy on attachment or execution. So this is talking about a contract for support, which doesn't exist in America. They don't have contracts. When you ask to see the contract in writing with your name on it, they don't have a contract. So there are no contracts in America for child support. There's fictional, pretend, imaginary one that they claim that they would have to use terms like debt and debtor and obligor and obligee. There has to be a contract, especially if they're claiming you're in default of it. When there's no existing contract, you can't be in default of it when it doesn't exist. There's no bond. There's no financial note with your signature on it saying you agree to pay a certain amount of money with terms and conditions, with expirations. We'll continue on with 208. Furthermore, contractual support shall be subject to adjustment whenever modification is necessary due to changes in circumstances, manifestly beyond the contemplation of the parties. That's the end of the stuff on support. So we'll go back to that. Back to the prayer for relief. It's taking way too long. That the existing and any prior and subsequent 7, that the existing any prior and subsequent child support orders in this case be vacated for having been filed in an improper venue where jurisdiction was not had, and shall be made null and void retroactively to the date the initial child support order was wrongfully issued by the 32nd Judicial Circuit Court of Ontonagon. Maybe I should be spiteful and add by Janice M. Burgess, judge. Pretend to judge without a license to practice law. Only a bar card. Number 8. So this is section 8. We're into the prayer for relief. That the existing and any prior subsequent child support orders in this case be dismissed for having been filed in a proper venue. I write this a few times, a few different ways, because I don't know. I want it double done. I want it terminated. I want it vacated. I want it dismissed. I want all triple done if I had all 3 of these things done, just to make sure it was gone. Be dismissed for having been filed in a proper venue where jurisdiction was not had and shall be made null and void retroactively to the date the initial child support order was wrongfully issued. Oh. 9, that the existing child support order by the 12th Judicial Circuit Court of Keweenaw County, the controlling order, be dismissed with prejudice for its enforcement by the Keweenaw County Friend of the Court and the Ontonagon County Friend of the Court. Be ordered to cease and desist all notices and threats under the color and law and efforts to collect such as liens, credit reporting claims, I have incurred a debt and in default of said claim debt, income withholding orders, license and passport suspensions, etc. are to be nullified and the adverse effects to be reversed by ordering the Keweenaw County Friend of the Court to formally rescind all said notices and enforcement actions they have undertaken and take all necessary actions to undo said enforcement actions. See if the court actually does that. They better. 10, that the county prosecutor be directed by the court to prosecute the Title 4D agency child support officer for having engaged in fraud by using threats via USPS mail under the color of law of arrest, suspension of driver's license and or passports, and practices of adverse credit reporting on the claim I have defaulted on an alleged debt. Committing crimes of stalking, aggravated harassment, and scheme to defraud by mail fraud under 18 USC section 1341. Love to see a court official, county prosecutor, prosecute a county friend of the court official. I mean, it only makes sense. Sounds the right thing to do. Sadly, our courts don't do the right thing. The American people have totally lost faith in our legal system. It doesn't follow the laws anymore. It's open. They're openly ignoring the law, openly doing as they wish. It's just disgusting. And it's a matter of time until an angry mob shows up and does something an angry mob would do with a corrupt official, or you'd hope or you'd think it would eventually occur. Throughout history, at some point it does occur. Just, are you that corrupt official? If you are a public official, it would be in your best interest to be as honest as you possibly could and not do stupid things that would anger the people to show up and want to get rid of you. Like the king in France. Back when France had kings, the people showed up and they weren't very nice. They were an angry mob and they did what angry mobs do when you're a corrupt monarch. It always occurs. Sadly, it doesn't occur fast enough. Sadly, criminals in office get away with things for decades, generations sometimes. In terms of crowns and monarchies, generation upon generation, they get away with all kinds of crap. And they should have been held accountable by an angry mob long before that. As an individual, you're just deemed a lone wolf. If you even try to organize a mob, though, then you're a terrorist. If an angry mob just shows up one day because it gets that bad, then they really can't do anything to you. But that's a lot of corruption, a lot of evil stuff that was done by the authorities up until that point when it finally gets to that day. Ideally, we don't want that to happen. Ideally, we want judges and lawyers and county prosecutors and politicians and elected representatives and governors and presidents to all just be lawful, honest people with integrity and not need to be, hung by the neck until dead, as is prescribed under Title 18 of the U.S. Code when you violate your oath of office. Hung by the neck, the body remain in state until dusk to serve as an example for anyone who would take their oath of office so lightly. That's what it says. It's in there. Hasn't been repealed, hasn't been, redacted. It's still there. It's still law on the books. Will a court follow through with it? Probably not. No, because they're the ones doing the crimes. How do you expect a criminal in office to hold criminals accountable, let alone hold themselves accountable when they're just a bunch of criminals? They're criminals protecting criminals, using public servants with public funds to oppress and prosecute the public when the public has a problem with them being criminals in office. It's a very ugly system we're under. Needs to change. Ideally, by the system, making the people within the system choosing to be better people. Going to happen? Not when you're that haughty and egotistical, typically. Maybe 1 in 1,000. 1 in 1,000 men, as the book of Ecclesiastes says. 1 in 1,000 men, you might find a good one. But 1 in 1,000 women, well, I'm not being that mean to women. I'm pretty sure there's just as many good ones. 1 in 1,000. 1 in 1,000 people who gets to a high, powerful position might be an honest human being. The rest are so corrupt or controlled by blackmail, or they've done so many things, so many favors that they're so entwined with the corruption they can't get out of it, if they wanted to get out of it. But usually they're having too good of a time, like Epstein and all his buddies, all his business buddies and politic buddies and actor buddies. They were having too good of a time being corrupt, wicked, twisted human beings. And they've been corrupt, wicked, twisted human beings, and Epstein got them on camera. So blackmail, they're not going to start being honest is the problem. You don't get to the highest level of government in our country, on states, I'm pretty sure even. The federal level, absolutely, you're not getting that high unless there's blackmail on you. Or you're the one from the one area of the country that's still honest and actually votes honestly and not in people's own self-interest, but they vote for a politician based on his character and not on his promises. And there's just not enough good people in it. Not enough people with self-control and integrity and the ability to make the right decision despite all the temptation and other evil things out there to scare you, coerce you, destroy your political career, destroy your personal life, destroy your family. Yeah, it just takes a few threats, and some people just stop running for president when they possibly could have made a difference. Ross Perot. Though the guy was involved in the Contra stuff. Him, Clinton, and Bush, all involved in running drugs. Very funny to see them up on stage debating who gets to be president, who gets to be the next corrupt character. He would have been better than both the other options, though. $11. And that all child support payments that have been collected from myself by Title 40 Michigan Child Support Agency via the Ontonagon County Friend of the Court and Keweenaw County Friend of the Court by any and all means it has been received under duress or without my consent to the Michigan State Disbursement Unit, MISDU, and paid to the mother via Michigan State Disbursement Unit, MISDU, since the initial support order was implemented in 2016 all the way to the present. Be refunded in full immediately, and all claims of arrears owed be dismissed with prejudice immediately. Reimbursement to include all administrative fees collected, but may exclude any amount the mother can show physical proof of in court in the form of receipts or proof of purchase for the daily needs, budget expenses, and educational tuition costs incurred for the financial support of our son, Abel Ryan Frost C. Campos Brook, or his younger brother, my legal under Philippine law, but not biological son, Alexander Thor Seabrook. As of July 14th, 2022, a total of $35,560.90 under duress without consent. As of July 24th, 2022, there exists an arrears claim of $996.64. I'm giving them options. I'm saying if you can prove that it went to supporting my kids, I don't need that back. But if it didn't, and you can't prove it, you stole it from me, and I should have it back. I really don't care if it comes from the mother. If they get it back from her, they're not going to get it back from her. She's in another country, a non-reciprocating country with no accountability process. They will never get a penny back from that lady. But they're the ones who took it from me. So they're the ones who should be giving me the money back. So it's a motion, something I can file in court. I don't know what else to do. Lawyers don't want to mess with this. They don't want to help. They're just going to charge me money anyway and not do much that I can't do myself, I guess, or try. The lawyers are all in on it. You really think a lawyer is going to honestly represent you in court or be able to make a statement like this to the court? They'd have their bar membership, their bar card suspended if they explained it to the court that the court was committing fraud and it was all wrong and the court needs to fix the freaking act. That this shouldn't be happening. But there's a financial interest by the court for there to be support orders and them to collect support orders because they get federal incentive funds given to them for the number of orders and the percentage of orders collected on. Thanks to William Jefferson Clinton, guy who totally cared about America, not himself, who implemented all this crap. We did lots of work to make all this corrupt crap happen, to totally destroy the American family. It's all part of an evil process. Highly compartmentalized government agencies with no idea exactly what they're doing or why they're doing it, except they're told to do it. The people on top of the system, on top meaning the ones who finance the president in his run, who control this guy with blackmail, who control the congressmen and finance their campaigns and have blackmail on all of them. The ones they control, that is. Not all of them have blackmail on them, but most do. Or something they don't want coming out of the woodwork. Some stupid story or press reporting, whatever. They're controlled. And the people on top who make this plan, who want to destroy the country, who want to create a system where there is no family. The family is the foundation of the nation. If you don't have functioning families, you do not have a solid nation. It'll destabilize it. It will cause it to collapse, which is what they want. They want control, and you can't have that when you have a strong nation because you have strong families. They want people to look to the media, to their televisions, their computer screens, for all their influence and all the ideology that they're going to get in life, of how they want to live their life. From the media sources that these corrupt controllers have control of and finance and put out. It's a large social engineering brainwashing scheme, and it's all about control. Psychological control, because these controlling psychopaths are psychopaths and they want to control people, for one. They think they know better than everybody else, probably due to arrogance or their lack of faith in humanity because of the same kind of crap that they keep doing. They're like, oh, humans are evil. Oh, that's because you're evil. You keep doing evil stuff. You evil human. Stop it. You have no faith in humanity because you are evil, not because the rest of humanity is evil, but because you are evil. So you won't trust humanity to be good. Whatever. That's the end of the motion and my ramblings. And I've pretty much read you everything. If you're dealing with Philippine family law issues, I highly recommend you go look up the Family Code of the Philippines, Executive Order 209. Title 8 deals with support. Title 9 deals with parental authority. Both very good sections to read and understand. And if you are dealing with any of this fun stuff and just want someone to talk to about it, to vent to, whatever, or you want access to the assortment of legal related things I found and collected and saved digital files over the years. I even have a copy of Jack McLamb's Vampire Killer 2000 I got from my grandfather. I got from my father, who got from his father. So haven't got to read it all yet. I hear it's a good thing to read and understand. How do we change the problems with society today? It has to be on a cultural level. It starts with individual choices, and you can't make those for other people, which makes it very hard and very frustrating. But you can make your choices, and you can set the example that other people can see and hopefully learn from your example and start choosing to do things like you do. Ultimately making the right choices in life, wise, calculated choices, not for your self-interest, but a constructive versus destructive effect in the short term and the long term. That's really what you define right and wrong as. Does it destroy something? Does it destroy things, people, lives, minds, hearts? In the short term and the long term. That long term one is the hardest for people to see. Because if you haven't lived long enough or you haven't seen it in your personal life, it's very hard to see. Which is why I recommend talking to some old people. They've been around a while and they've seen some things. And one would hope they could usually give you some good advice. But if they're all about themselves, I wouldn't be getting any of their advice. People who care about others, not only themselves or more than themselves, and have lived a long time, are the people you want to get advice from as to how to live your life. And that's what you can do. That's what you can do on a daily basis in everything you do, every decision you make, how you report your time when you're at work, like I am right now. I'm not working right now. I'm not reporting hours that I'm working right now because I'm not working. I'm doing something I wanted to do because I wanted to do it. So I go off the clock. That's integrity right there. I'm not lying. Like, nope, I wasn't on the clock. I didn't get 40 hours this week because I was off the clock most of Wednesday, writing up a legal motion, brooding about what am I going to do with this stupid court process I'm dealing with. And I'm off the clock, it seems, all afternoon this Friday because I'm doing something else that I feel moved to do. You set the example that other people see. That is how you can make a difference in the world. You choose who to vote for. You choose where to spend your money, who you spend your money on, who you give your money to, what companies you buy from. And you can look up who these people are and try to do your best to figure out what you're supporting financially in your financial decisions. There's a lot of deception when it comes to government stuff, like taxes. They con you into filling out a W-4. If you didn't fill one out, they make an assumption of your liability and assume you have a liability and then come after you as if you have a liability. If you submit an exemption withholding certificate in lieu of a W-4 that explains you're not liable, which I have a copy of, then you don't have a contract with them, and they have no contract to take you to court for, claiming you didn't pay it. You don't have to support the corruption in the system because they require your consent in order to tax you, because they can't tax you. There is no power. The Constitution didn't give them the power to levy an income tax against the American people. They can tax federal employees. They can tax people who work for the federal government because it's called an internal revenue tax for a reason. It is internal. It is within the federal government. It is not upon the American people. When you sign a W-4 that your employer gives to you and is told they cannot tell you how to fill it out because it's a contract, and if they told you how to fill it out and to fill it out and you must sign this, that would be a breach of contract. It would be fraud in a way. It'd be a breach of contract though, and then it's an unenforceable contract because you weren't the one who made it. You weren't the one who willfully entered into it. You were told to do it and told you can't have a job unless you do it. And you did it in order to have a job so you could afford to support yourself and take care of yourself and your family and whatever else. Assuming you're lucky enough to have one of those functioning things anymore. And that's a cultural problem that also needs to change and starts with people making their own decisions to be better human beings, to communicate with each other, to talk about their problems and to fix their problems without ego or pride, selfishness or greed or lust getting in the way of doing the right thing, the long-term constructive, creative effect on the family, on relationships, on friendships, on the whole social interaction you have in the world. I think that's about all for now. Save those little grammar changes I made. And I'm going to click the end button.